Hi, I'm Florida Attorney General Bill McCollum. As Floridians, we're granted the constitutional right to inspect and copy public records and access government proceedings at both the state and local levels through the Sunshine Law. My office has created a series of short, informative videos to help you better understand the Florida Sunshine Law and how it can be used to serve your community. I trust you'll find these videos useful and beneficial. More information is available online at myflsunshine.com. Enjoy.
The Florida Supreme Court has determined that public records are all materials made or received by an agency in connection with official business, which are used to perpetuate, communicate, or formalize knowledge. They are not limited to traditional written documents. Tapes, photographs, films, sound recordings, and computer records are also considered public records, subject to inspection unless a statutory exemption exists. First, let's talk about what public records law requires of public agencies. An agency may not impose its own restrictions on access to or copying of public records. Every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so, at any reasonable time, under reasonable conditions, and under supervision by the custodian of the public records. A custodian of public records may not impose a rule or condition of inspection which operates to restrict or circumvent a person's right of access. A policy of a governmental agency cannot exempt it from the application of Chapter 119 of the Florida statutes. Chapter 119 provides that it is the policy of this state that all state, county, and municipal records are open for personal inspection and copying by any person. A public employee is a person within the meaning of Chapter 119 of the Florida statutes, and as such, possesses the same right of inspection as any other person. The legislative objective underlying the creation of Chapter 119 was to ensure to the people of Florida the right freely to gain access to governmental records. The purpose for requesting public records is immaterial. Chapter 119 does not authorize an agency to require that requests for records must be in person or in writing. It does not matter if the request is in writing, over the telephone, or in person, provided that the required fees are paid. Additionally, a person requesting access to or copies of public records may not be required to disclose his or her name, address, telephone number, or the like to the custodian, unless the custodian is required by law to obtain this information prior to releasing the records. For example, the agency that furnishes a motor vehicle or vessel registration record is required by statute to record the name and address of the person other than a representative of a law enforcement agency who requests and receives information from a motor vehicle or vessel registration record. The agency is also required to record the name and address of the person who is the subject of the inquiry, or other information identifying the entity about which information is requested. A public agency may maintain a record of public records requests made to the agency. However, as noted, the person requesting records cannot be required to disclose identifying information, nor can the agency require the requester to fill out such a form or documentation. The statutory obligation of the custodian of public records is to provide access to or copies of public records at any reasonable time, under reasonable conditions, and under supervision by the custodian of the public records, provided that the required fees are paid. However, the Public Records Act does not require a town to produce an employee, such as the financial officer, to answer questions about or discuss the financial records of the town. In other words, Chapter 119 provides a right of access to inspect and copy an agency's existing public records. It does not mandate that an agency create new records or reformat its records to provide them in a particular form in order to accommodate a request for information from the agency. For example, the clerk of court is not required to create a list of documents from a case file in response to an inmate's request if such a list does not exist. However, an agency must respond to requests for information as to copying costs. Additionally, the mandate that an agency produce all non-exempt documents in its custody that are responsive to the request applies only to those documents in the custody of the agency at the time of the request. Nothing in the public records law appears to require that an agency respond to a so-called standing request for production of public records it may receive in the future. Now let's talk about the time requirements of the public records law. The Public Records Act does not contain a specific time limit for compliance with public records requests. The Florida Supreme Court has stated that the only delay in producing records permitted under Chapter 119 is the limited reasonable time allowed the custodian to retrieve the record and delete the portions of the record the custodian asserts are exempt. An agency's unreasonable and excessive delays in producing public records can constitute an unlawful refusal to provide access to public records. While an agency may restrict the hours during which public records may be inspected to those hours when the agency is open to the public, a records custodian is not authorized to establish an arbitrary time period during which records may or may not be inspected. For example, an agency policy which permits inspection of the public records only from 1 p.m. to 4:30 p.m. Monday through Friday violates the Public Records Act. There may be instances where, due to the nature or volume of the records requested, a delay based upon the physical obstacles in retrieving the records and protecting them is necessary. However, the adoption of a schedule in which public records may be viewed only during certain hours is impermissible. An agency may not allow the maker or sender of documents to dictate the circumstances under which the documents are confidential. The only entity that has the authority to exempt public records from disclosure is the legislature. Finally, let's cover some issues related to denial of access to public records. A custodian of a public record who contends that a record or part of a record is exempt from inspection must state the basis for the exemption, including the statutory citation to the exemption. Also, upon request, the custodian must state in writing the reasons for the conclusion that the record is exempt. Where a public record contains some information which is exempt from disclosure, Chapter 119 requires the custodian of the document to redact only that portion of the record which is exempt and provide the remainder of the record for examination. A public officer who knowingly violates the provisions of Florida's public records law is subject to suspension and removal or impeachment and commits a first-degree misdemeanor punishable by a fine of up to $1,000 and a jail term not to exceed 1 year. An unintentional violation is a non-criminal infraction, punishable by a fine up to $500. Attorney's fees and court costs are available to the requester that prevails in a civil suit for access. The state attorney's office has the statutory authority to pursue criminal charges against a public official for violation of the public records law, including those violations which may result in a finding of a non-criminal infraction. A person who has been denied the right to inspect or copy public records may also bring a civil action against the agency to enforce the terms of the public records law. Actions brought under the public records law are entitled to an immediate hearing and should take priority over other pending cases. The Office of the Attorney General has a voluntary mediation program available as an alternative for resolution of open government disputes. You can call the Attorney General's office for mediation at area code 850-245-0140 or visit our website at myfloridalegal.com. Open government isn't just good government, it's the public's right.